Morning, Your Honor. I will be
Appealer.
pleading non-guilty today, and I will be representing myself.
They say a man who represents himself has a fool for a client. I am that fool.
Okay, there's a certain way we go through things. Just bear with me a second. So the first thing is that you're charged with failure to stop and give information. You're facing up to 6 months in jail and or 2,000. I know that you're ready to say, go through your list of this and that, but because you want to talk, you're not listening. I need you to listen for a second. I'll give you time to talk, I promise. Just let me get through the spiel and then I'll give you an opportunity, okay? You're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, we're just going to do probable cause because I don't know what happened. Maybe there's no probable cause and then you're out of here. I don't know. Stop. You have the right to remain silent. Exercise that. They're DAs. Every single thing you say, they're going to sit there and type to use you.
I know that's my right.
Guilt. Just hold on. Let's do probable cause first.
Okay. Yes, on June 15th, 2024, officers were dispatched to a crash. They met with the complainant who reported that she was involved in a crash with a Toyota Tundra and provided the license plate number. The officer, the male with gray shorts, no shirt, and tattoos stepped out of his vehicle and offered the complainant to follow him back to his house, and the complainant declined the offer. The defendant then left the scene without giving any information and sideswiped the complainant's vehicle a second time. The officers began to head to the car's registered address, 0.4 miles away, when they received a second call for help at the address they were headed to. At the address, a male matching the description provided by the complainant was having a mental episode in front of his house. The defendant admitted to driving and leaving the scene without giving information. The damage was approximately $2,000.
Okay. All right, Mr. Peeler, I'm going to find that there's probable cause to go forward with your case. How old are you, sir?
So on June 15th, I was in a state of psychosis, and I have documentation of the settlement that took place for the liability property damage which occurred on that incident. I have the claim number in front of me if you need it, Your Honor, for that settlement. I have the mental health crisis documentation discharge summary provided by the Harris County Constable living at 13800 Lake Superior Lane if you need that. Upon further request, I can provide documentation of the discharge from the hospital that I went to.
Let's do this.
Supporting the mental health.
Mr. Peeler.
And I'm disabled. So.
Let's do this. Why don't I have you talk to a lawyer? Okay. Your lawyer can talk with you, get to know you, find out what happened, and then they can approach the state to try to, see what's going on.
But I'm disabled and I don't want to be, and I never was.
Just don't say anything.
Warrant at all. I never received anything in the mail, not once. So how can
sometimes cases work like that. Sometimes a person is involved in some kind of situation where a warrant will not issue immediately to where they get taken into custody at that time. So those are called
in the mail. So I assume that I would have received something.
Never assume anything.
You're right.
Never assume anything. But let's do this. I can have you talk to a lawyer here momentarily. You can explain your situation to the lawyer. The lawyers can talk to the DA, and then we can work something. Okay.
So
just hold on. Hold on.
I agree.
I don't want you to say anything because there are a bunch of DAs here and everything you say, they're going to use it against you. I will give you the opportunity, but first let me have you talk to a lawyer. I've got a bunch of them and they're great. They truly will help you out. Okay, really. Yeah. So let's do this. I'm going to have you go to Victoria, sign and reset. I'm just going to have you take a seat in the jury box while I find your lawyer. Be patient though. I've got 150 people here, Mr. Peeler. Okay, so just be patient. Okay.
Failure to, well, I actually did stop. I mean, for the record, we both have exchanged words outside our vehicle.
Okay, come on.
Proctor, Bessie,
Judge, I need to approach on Mr. Carter Peeler. Judge Peeler.
Yeah.
Judge, my client's 29 years old. He's got a history of mental situations. He's here with his parents.
Oh, where's mom?
Well, mom just went down to pay some parking, but dad is here.
Yeah, come up, Dad.
Judge, I mean, they have some, they have documentations of all of his mental challenges. I'm on the case, but I'll review the meds and all that, and it actually may be a better case with the PG's office. I'm not sure, but I mean, I know he's.
Hi, Dan.
He gets nervous.
Thanks for coming.
easy.
Thank you.
There's no reason for you to be nervous.
So,
Really, it's not the end of the world. You've picked up a case, but it happens. When you do that, you dust yourself off, pick yourself up, and you move on. All we want you to do is just don't violate the law. Do you have a Texas driver license? Do you have liability insurance? Okay, you can continue to drive. Just be careful. If you happen to get into an accident, stop. It's not the end of the world. That's why you have car insurance, so that if you get into an accident, they're there to help you with what happened. They'll even give you a lawyer to represent you. That's why you pay for car insurance. Really.
I didn't know they give you a lawyer.
Well,
your insurance company.
not every single time, but
Okay.
you know, like if someone were to sue you and you
Yeah.
have car insurance, you know, typically there's a lawyer to help you out with these cases. Yeah. So that's why you pay for car insurance. That's why it's as expensive as it is. So I'm not putting any conditions on your bond, okay? Just be careful and be safe. That's it. We've given you a lawyer. Just stay in touch with John and he'll tell you how to navigate through this issue, and that's it. Do you have any questions? The only other thing I'm going to tell you is that if you take medication, psychotropic medication, continue to take it. When you stop, you know, I see so many people, they start taking it and they start to feel good. You know what? I don't need this anymore. I feel great. They stop taking it, boom, same thing starts happening. You know, they evolve in that circular, just end up in purgatory because they stop taking it and they end up back into the same situation and into bad things start happening. If good things are happening when you take the medication, keep taking it. It's there for you to do well and to be well, to be better. And that's what the medication is there for. Don't stop taking it, because when it does, that's when things spiral out of control. You know, we're here to help you. That's why we have lawyers. That's why we have, yeah, okay. Questions? Just relax. Everything's fine. If you guys need anything, we're here for you. You can always come back here and then we'll help you out. We'll set you off a month. If you need anything, just come back and we're here for you. Okay? All right, guys. Take care.
Need to sign.
No, just a reset. Yeah. Okay. You are Alvaro Betancourt.
Yes, sir.
Mr. Betancourt, you're charged with assault of a family member.
Jafar, he's our man. If he can't do it.
You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On November 4th, 2024, officers were dispatched to an address in Harris County, Texas, in reference to a family disturbance type call. The caller was the witness Graham, who called 911 stating that he heard the complainant in the background of the phone call crying, stating that she was having a domestic disturbance incident with her ex-boyfriend. Officers arrived on scene that was indicated by the witness and spoke with the complainant. The complainant stated that the defendant is an ex-boyfriend of hers who she shares a child with. She stated that on this date they were in bed together when the witness called her. Witness Graham, and the defendant saw the witness call her, became upset and stated, "I will kill you and her and go about my day." The complainant began to cry and told the witness she was having issues with the defendant. The defendant then grabbed her by the wrist and began to physically slam her in the bedroom walls, causing pain to her upper body and pushing the complainant into the hallway outside her bedroom, where he again slammed her into the hallway walls. This was witnessed by her 8-year-old juvenile daughter.
So the daughter sees this happening.
The daughter sees this happening.
Not his biological daughter though, right?
No, his biological daughter is 7 months old, so there's 2 daughters.
So he does have children with her.
Yes.
Officers pulled the defendant's photograph, who the complainant positively identified as the defendant. She stated that they'd been separated for over 6 months, and the defendant became angry when the complainant told the defendant she had a new relationship already. Officers tried to reach the defendant, but were unable to.
So she has a new person.
So she indicated, Judge.
Okay. Mr. Betancourt, I'm going to find that there's probable cause to go forward with the case. I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Irma Becerra as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, the stalking statute. You cannot stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works.
Judge, if I may, my understanding is that the complainant and my client are living together, that they're still together. I was wondering if you would be able to do a no threatening and harassing content, say that they also share a child.
Until I know what she wants, I'm not going to do that, right? They've been unable to reach her. And according to what they're saying is that she has a new beau. So I don't know. Until I know, I like to honor the wishes of the complaining witness. And until I know that she wants to have contact, I'm ordering you not to have any contact with her. I don't care what you're going. I don't care what you're doing. No means no. I don't care if there's a burning building and she's in there, you have to go save her. A court order is a court order. If you violate this, I'm going to put you in jail. Are you a United States citizen? I don't know if you are or not, but if you're in this country without permission, if there's any problem with your immigration paperwork and immigration finds you in custody, they will put an immigration detainer and you will be stuck in there until this case is over with, and then they'll ship you off to immigration. Don't violate any of these conditions. Don't pick up a new case. No contact, no weapons. Do you understand?
Sure.
Anything else?
No, Judge, that's all.
Now, have you run his NCIC? What kind of criminal history, if any, does he have?
Just a moment, Judge, I'm pulling it up.
You need to do a bond because there's no bond that's set.
And he has a bondsman here. I was wondering if you'd approve of Walter. I was wondering if you,
Well, if he has no criminal history, I was going to give him a PR bond,
that works as well.
but I don't know what his criminal history is, so.
As for criminal history, I see a sexual assault out of Rio Grande City that has no disposition. A driving license invalid out of Brazoria County. That was a conviction.
That would be, curious about what happened with that sexual assault.
Another driving with license suspended in Brazoria County. Another driving with license invalid in Montgomery County. And then a aggravated assault with a deadly weapon in Brazoria County. But that was, I see a final pleading of not guilty, but I see no disposition on the case.
You're setting your bond at $5,000 and he'll have to make a surety bond. Do you have a Texas driver license, Mr. Betancourt?
Yes, I still have it.
Does he have, can you run his license to see if he has a license?
Yes, Judge, I'm running it right now.
I'm ordering you not
Okay,
to drive
so
any
how many-
vehicle unless you have a Texas driver license and liability insurance in your name, Mr. Betancourt. Do you understand? Like I said, I take public safety extremely serious and I will do everything in my power to protect the public. If that means putting your bond at $10 million, I'll do it in a heartbeat to protect the public. So be careful when you're out there. Actions have consequences. Do you
A
understand?
valid driver's license.
Okay.
Yes, sir.
All right. Now you have a lawyer. It's your responsibility to stay in touch with them and they'll tell you when you have to come back to court. If they tell me they can't get a hold of you because you're playing games, I will issue a warrant for your arrest. You will not get any more PR bonds. No, or you won't get any PR bonds. Do you understand? Okay. Do you mind drafting all those conditions, please?
Yes, Judge.
Okay. All right, guys. Thanks.
Thank you, Judge. May we be
All right.
excused?
He cannot go because we need to do everything, and then you said he has a bonding company here, right?
Yes, Judge.
Okay, we'll release him to the bonding company here when we get all the paperwork done.
Thank you,
Okay,
Judge. I'll go ahead
thanks.
and resend him in the meantime and have him.
Don't, because he still has to post bond. Once you post that bond, you'll get a 7-day setting. When you get that 7-day setting, feel free to come up here and we can give you a different day.
Yes,
You know?
Judge.
Yeah, okay,
Hey, Judge.
Ricardo. Ms. Steen, you are charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On June 25th, 2022, the complainant said the defendant needed somewhere to stay for the night. The complainant let the defendant stay the night at her apartment and went to work the next day about 9:30 a.m. The complainant asked the defendant if the complainant could take her laptop to work. The defendant said the laptop wasn't. I apologize. The complainant's laptop was not in the apartment. The complainant said the laptop's last known location was in her bedroom on the bed where the defendant slept. The complainant left the apartment and tracked the defendant and her MacBook Pro at about noon. The laptop was at the defendant's residence and was valued at $750. The complainant told the defendant to return the laptop. The defendant said to pick it up and she will give it back.
She got it back?
Your Honor, I don't have that information.
Morgan, do you know?
Let me check the OR, Your Honor.
Steen, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. You understand? If I find that you have contact, if I find that you're in possession of any weapons, I'm going to revoke your bond. I will put you in jail.
Your Honor, the police took it into custody. So the police took the laptop. We don't know if the complainant got back the laptop, but
Okay.
police were able to-
So she has another theft that was just dismissed now. Same MO.
Let me see, Your Honor. For the prior theft, it was, in that case, the complainant stated the defendant lived with her and realized her cash out balance was low and that she found $970 missing from her account and that the money had been transferred to another debit card without the complainant's knowledge.
What do you do for a living, ma'am?
I work at Sonic. The laptop, my mom did return it back. We sent it back to her.
Are you working now, ma'am?
Yes, sir.
What do you do for a living?
Sonic. I'm a cook.
So you have a full-time job? Okay. How much money do you make a month?
I'm not sure. I get paid $11 an hour.
Okay. Did you want to apply for an appointed lawyer, ma'am?
Sure, that's fine.
Okay. Do you mind giving an application? I'm going to give you a PR bond now. I'm going to tell you now, Miss Steen, I'm going to do everything in my power to protect the public in every way. And if I find that you become a danger to my public in so much as taking anything from anyone for any reason, from Walmart, from anywhere, I will put you in jail. You will not get any more PR bonds. Do you understand? This is the one you will get from me, and there will be no more if you pick up another case or you become a danger to my city. Okay. Do you mind giving her? Did you get the cause number on this? Okay, guys, can you file no contact?
Judge Tammy Johnson.
Yes.
So her bond is set currently at $1,001. She doesn't have any ability to make bond from kind of going through the procedural background of the case. It sounds like she'd gotten a GLB bond originally about a year ago.
Wow, she's been gone that long.
Well, did not come to a setting and have a chance to meet you, Judge. And so, because had she have gotten an admonishment from you, she'd have certainly attended.
Good try. Can you bring up Ms. Johnson, please?
She does not have any criminal history, and this is kind of a neat of you. I've chatted with them briefly about it, but the allegation is that the police found her asleep in a parked vehicle at a gas station. And with the car in park, but they say on.
I've
So-
done the research. We had this issue not a week ago, and I'm telling you,
Well, it's sufficient, from a legal sufficiency standpoint, it can stand, but what do jurors think?
I combed through like 20 cases. We did the diligence as far as that argument is concerned. My only concern now is that she's been gone for how long? But for this, she would still be wherever she is, right?
Well, she's got a kind of difficult financial situation. She's got family, but she's talked to her family and doesn't have the ability to make even what would be roughly paying $150 to get.
Right.
And, but she's 43 with no criminal history. She's got 2 children that she successfully raised to their young adults.
Come up, ma'am. You were Tammy Johnson. How's jail? How's jail?
It's different, Judge.
Why do we have jails?
Criminals off the street, I guess.
Yeah, that's a good reason for sure. Why else?
Judge, she knows.
To make sure you come back. And when you don't, the sentences get longer, the bars get colder. Just, that when you fail to appear, your bond's at $1,000 right now. So all that needs is $100 and you're out, $125, you're out. You now know that you have no one to pony up that kind of money, no one to pony up that kind of money to get you out. Mr. J.A.s is asking me to let you out. The only reason you're here now is because you got busted. Otherwise, you'd still be out who knows where. Why would we let you out? You tell me.
She wants to move forward and deal appropriately with the case, and the state has given me quite a bit in the way of discovery to review. And as with any type of blood case, there's probably going to be more that we venture out to seek, but it'd be obviously sometime, we talked about it, the idea that these can take 6 months, 7 months to even get ready to see if it's a viable case for trial.
Therein lies the problem where, ma'am, you sit now in custody until the case is either pled, you're in trial, or somehow gets disposed of. That could take 6 months. Where have you been?
I'm trying to get my life together.
Judge, she's worked for a long time as a waitress and is living, and she's living kind of difficult situation at the moment. So it's experienced bouts of homelessness but now has a more stable situation. She has the ability to get to court and will be here. That's the representation we're making to the court. And I think we can do short resets if you'd like.
Mr. J.A.s, I never want to leave someone in custody. But one of my primary concerns also is not putting someone out on the street. And I'm telling you now, I'm willing to give you another chance. But I'm not gonna put you out on the street if you ain't got nowhere else to go.
She does now. She's living in she has a motel that she's living in now, kind of temporary housing.
Yes, it's permanent. It's been for a while.
I don't believe that for a second. Who do you have in your life that's willing to take you in?
I've got that information.
Before I had no one, but now I do.
But he just doesn't financially have the ability to.
The only thing that's changed between now and then is you got arrested. Ms. Johnson, the last thing I want is you to be put on the street where you look like you're going to start using again, because I don't want you to use. If I were to drug test you now, what are you going to test positive for?
Any discussion about that?
Here's the drug. I'm going to drug test you like crazy. And if I find that you're using, then I'm going to keep you. And I'm not going to play this game. You can't even look at me in the eye.
Drugs aren't a problem.
Stop. Don't. Okay. At this point, Judge, I'm going to admonish my.
It's okay. That's all right.
So
where do you have to go?
Judge, let me answer all the questions. She lives in a motel, stable situation, can make her way back to court. And you can do short resets and we'll be here. And that's the understanding that we've talked about and I think would be appropriate at this time would be to give her a chance to come in, and obviously we'll comport with all the requirements that this court installs. And if we have to do testing, we'll do that. And
Let me make something perfectly clear to you, Ms. Johnson. I don't like it when people plead guilty just to plead guilty to get out. I'm not down with that. And we're not going to play that game here. So if I let you out, I expect several things from you. Number one, that you're not going to endanger my public. That's the first and foremost. Number two, that you're not using alcohol and or illegal drugs. And I'm telling you, I'm going to test you like crazy. If you can't stop on your own, then we will do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Sure.
Number three, if you don't have a license and liability insurance, you are not allowed to drive. Do you have a Texas driver license? Then you will be signing with me today an affidavit. This is a promise you're making to me that you're not going to drive. And I don't care if Jesus needs a ride to church, you get into a car and drive. I can have a contempt hearing and you'll be facing 6 months every time you drive. Do you understand? Do you want me to give you a PR bond? Can you stop using?
Yes, sir.
I'm going to let you out and I'm going to have you come back here on Tuesday. And I want you to come back and take a test on me on Tuesday. And I want to know for sure. You got to understand, you've played Monopoly, right? What do you get in Monopoly to get out of jail? What do you get? You get a get out of jail free card, right? This is the only one you're going to get. You're not going to get another one. You understand? So I will let you out now, but I expect you to comport and comply with conditions. And that's it. I'm not asking for much. I'm just asking you to be sober and come back to court and stay in touch with counsel. That's all.
thank you, Judge.
Of course.